Thanks, Andy. Good morning, ladies and gentlemen. Welcome back to the reconvened meeting of the local review body on Thursday, 25th of November. We are still on agenda item number 4, Low Barley, Gatehouse of Fleet, refusal of planning permission for change of use of agricultural buildings to form 2 dwelling houses, alterations and extensions, formation of car park and turning area, and installation of 2 septic tanks and soakaway systems, case number 20/1489/full. I asked the clerk to provide an update regarding the further procedures agreed on the 9th of September 2021. Can you now outline the procedures, please, Claire?
Okay, thank you, Chair. I can confirm that on the 9th of September 2021, members went through the papers for item 4. The LRB determined they wished to request further written submissions to allow the document that had been circulated privately to some members to be formally submitted, and also provide the opportunity for officers to review that information. Members were provided with copies on the 16th of November 2021. You have a procedure letter to the agent, a letter dated the 12th of August 2021 from Christie Gillespie Consulting Engineering, structural inspection of Low Barley Farm, Gatehouse of Fleet, Castle Douglas, DG 72BH, and you have the observations of the appointed officer on the additional information submitted, being that the letter of inspection just outlined there. Thank you.
Thanks very much, Claire. I've certainly received these documents. I presume all members have. If you have not, please let me know. And if everyone's content that they've received these documents and had the opportunity to scrutinise them, do we now have sufficient information to determine this review? And I will take no comment as an agreement that we have enough information. If anyone does not, please let me know. I take it for granted, members, that we have enough information now to proceed to determine this request today. So, going back to the original documents which we've all kept, or in my case, had them renewed, we have the contents with the notice of review and related documents, pages 13 to 34. If there are any questions or observations, members, now's your opportunity. There's content number 2, report on handling and related correspondence, pages 35 to 82. Oh, Paula Drysdale, please.
Thanks, Chair. It was just really to check with yourself or Billy, if it's appropriate. Obviously, we've seen all the reports with regards to the 3 things that can be done with the timbers, but did we need to ask Billy if it's important as to what the end structure will be like if we do decide to go ahead with regards to the timbers? That, in my mind, would only change the roof. So, is that something we need to discuss today, Chair? That's really all I'm asking. Thanks.
Yes, my intention, Paula, was to go through the contents of the document we've already had and then focus on the additional information we required. And at that time, we will discuss what we want to see as a local review body, and then we'll ask advice from Billy whether or no we can place that as a condition or refusal or whatsoever. So if you're happy, Pauline, we'll just quickly, I'm not meaning quickly, but we will go through progressively the document, the large document we've already studied, and then focus on the additional information required before we get to a debate on how to move this request or this appeal forward. If you're happy with that, Paula?
Yes, I am. Thank you very much, Chair.
Thanks, Paula. Okay, so we're on contents of the original document, the report on handling and related correspondence, pages 35 to 82. If there are no questions on that, we'll go to agenda item 3 on the contents. And members, we can refer back to the original document at any time during our ongoing discussions. This is just if you have any questions on the document itself as it was presented earlier in the year. the observation of the appointed officer on the applicant's agent's notice of review, pages 83 to 86. Okay, 4 is comment of applicant's agent on observation of the appointed officer, pages 87 to 90. Agenda item 5, planning application form submitted on 3rd December 2020, associated plans and supporting information, pages 91 to 220. 6, the decision notice from the Refusal Galloway Council dated 10th of March 2021, pages 221 to 229. 7, relevant extracts from Refusal Galloway Local Development Plan 2, pages 231 to 239. 8, photographs of application site and the locality, pages 241 to 244. And then, of course, we come to the grounds of refusal. It has not been satisfactorily demonstrated that the proposed buildings are capable of redevelopment without substantial demolition and rebuilding, which would be contrary to the terms of the guidance within the LDP2 supplementary guidance on housing in the countryside at section 7, and the LDP2 supplementary guidance on conversions of traditional buildings at section 2, which both relate directly to Refusal Galloway Local Development Plan 2, LDP2 and Policy H3. And the applicant has requested that the review be dealt with on the basis of an assessment and review documents only, with no further procedure. Now, having said that, we carried out a further procedure, and that was to seek additional information, which we have received. So, the grounds stated in the notice of review: the proposed developments for the conversion of 2 existing agriculture buildings to provide a new home in each building is agreed between the appellant and the planning authority that the existing buildings are traditional and that conversion represents an opportunity to secure the future for both buildings. Professional advice has been obtained from Marsh & Riddle, who hold professional indemnity insurance to advise on the structural integrity of buildings, which identifies that both buildings are structurally intact and capable of conversion, included within the proposed development. It's considered that the works identified in the structural condition report, installation of new beam beneath the roof, the ridge roof, cannot reasonably be understood as extensive or substantial rebuilding. Therefore, the proposal is considered to represent the conversion of traditional buildings in the countryside to new houses and to be acceptable in accordance with Policy H3. Vehicle access proposed via an existing opening to the public road. A consultation response was received from roads, which did not object. The applicant does not seek special treatment or accommodation, as is prepared to accept conditions recommended in the consultation responses of the Council's officers and partners. A condition precluding demolition and rebuilding of existing buildings is considered to be acceptable. So if we can move then, members, to the additional information we have received, and that is the letter from Christy Gillespie and the response or observation of appointed officer on the additional information submitted, which is a letter on inspection from Christy Gillespie Consulting Engineers. And we are asked or reminded to consider, and then we'll get into a discussion in detail about these 2 documents. Does the proposal comply with the terms of the development plan in principle? In particular, does the proposal meet the terms of LDP2, Policy H3 in principle? Does the proposal accord with the guidance set out in the adopted LDP2, supplementary guidance relating to housing in the countryside at section 7? Does the proposal accord with the guidance set out in the adopted LDP2, supplementary guidance relating to the conversion of traditional buildings? Specifically, has it been satisfactorily demonstrated that the proposed new dwelling houses are capable of being formed without the substantial demolition and rebuilding of the affected existing buildings? If it is not considered that the proposal accords with the terms of the development plan, are there a set of material considerations of sufficient weight to justify a departure from the terms of the development? If so, what reasons would members give for such a decision if it was considered that the proposals depart from the terms of the development plan? If members are minded not to uphold the appointed officer's decision and instead grant planning permission for this proposal, what set of conditions and reasons would members wish to see attached, if any? And if members are instead minded to vary the terms of the appointed officer's decision, what changes to the specific reasoning for the decision would be required? Having outlined the documents within members' papers, it now falls to the LRB to determine whether there is sufficient information to consider the review. It is confirmed that no representation from any party will be heard today. And the options available to the local review body today are that it can, and we've already done this, decide there's sufficient information before it to enable to determine the review today. We have requested further information in the form of written representations, and we have them to hand, which we will discuss in just a few moments. And we can, if we choose to do so, resolve to seek further information or hold a hearing again specifying who will be invited to speak and what matters they'll be invited to speak on. We can resolve to hold a site visit again, or a site visit accompanied or unaccompanied. This can be done in conjunction with any of the above, but would obviously not allow a decision to be made today. And if the local review body resolves that there is sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. The decision notice will include a statement of the terms in which the planning authority decided the case reviewed. For this case today, a planning advisor is present at our meeting, Billy Murray. It is confirmed that they have not had any involvement in this case and were not the case officer or the appointed officer for this application. They are purely here to provide independent advice as needed on matters of planning policy, law, process for the local review body. A solicitor is also present here today and will act independently if the local review body require any specific advice on matters of law. If members are clear and there is no further clarification required, I'll now lead the debate, and in the first instance, we will go through the agenda papers today and decide if sufficient information before it to make a determination. Well, we've gone through the papers today and the notice of review papers, and we're satisfied that we have no further questions in respect to that at this moment in time. We now have a letter from Christy Gillespie, which I am sure all members will have read, and we have the observations of appointed officer Robert Duncan on the subject matter. So, do members have any questions, observations or proposal they would like to make? Or questions? If not, we'll simply go into the debate on the merits of the additional information we've received today. According to the correspondence from Christy Gillespie, it would appear that the existing masonry walls would be consolidation and repair as opposed to rebuilding, as there are no clear indications the walls have moved significantly in recent years. There is a horizontal thrust, which has resulted in the walls being bowed over time. Any works to the properties would need to remove this thrust from the walls and can be achieved in a number of ways. The most common method would be to install wall ties at ceiling level. A further option in constructing a new load-bearing partition inside the existing stone wall. And a further consideration is to be made of the overall condition of timbers elements of the property. It is recommended that a dedicated timber survey is undertaken as part of the follow-on works, as there are a number of locations where significant decay and wood-bearing insect infestation have occurred. It is likely the capacity of the affected elements will be compromised, requiring treatment and possibly repair or replacement depending on the extent of decay. Deterioration of the timbers led to localised parts of the roof collapsing in a number of areas, and intervention works should be undertaken to minimise any further degradation. Timbers should be inspected on an individual basis to assess the correct level of work for each element. And this is the paragraph, members, we should maybe focus upon. It is feasible that all of the options listed can be undertaken without significant rebuilding of the existing structure, with only localised repairs to the stonework carried out. The most suitable option would be derived following further, more intrusive investigations into the foundations, as well as detailed timber, rot and masonry surveys. These additional investigations will inform the certifying structural engineers on the project which option will be the most suitable for the proposed works. That's the Christy Gillespie letter. And from the response from Robert Duncan, Christy Gillespie Engineering visited the site, and the purpose of the inspection was to review the condition of the existing building and comment upon the integrity of the structures. 3 methods of addressing stopping the horizontal movement of thrust and external loss may propose the documents on to confirm it's feasible. However, the method selected would be dependent upon further investigations. From the information submitted for each of the 3 options, it would appear that these will all involve internal works, will not impact on the external appearance of the building, but this has not been ascertained as no drawings or any of the proposals have been submitted. The information provided, however, has confirmed that there is a way forward, although not specified at this point, to convert the building in question without the need for substantial demolition or extensive rebuilding. The case officer advised that she does think they have gone at least part way to addressing the problem, but she'll be seeking confirmation that the proposed works would have no impact on the external appearance of the building, and that ideally they should have carried out a structural survey and proposed a detailed solution, which hasn't been done. So, members, we have before us either the case officer's decision to support, or alternatively, come forward with proposals of ourselves that would allow the applicant to carry out further works with an assurance that if they met the council's requirements, that support could be given to an application for conversion of these 2 dwellings, or these 2 agricultural dwellings into domestic dwellings. I would be content if we could to find a way forward that would place a condition on the applicant that before any works were to commence, that they had to carry out a full structural survey and provide the necessary information to satisfy our case officer that the project is a feasible one, and we could then support the application on that basis. I'll maybe ask Billy Murray first. Billy, if members were minded to place a condition on the applicant to carry out specific and detailed surveys, the type and number required by the council before we approve an application, is that something that's fair and reasonable and something we could do?
Chair, just to go back slightly, in terms of your officer's recommendation and your officer's analysis, the reason for refusal is actually a reason on principle. They're saying that it has not been satisfactorily demonstrated that the proposal would meet policy H3 and guidance in principle, because there is insufficient detail to show that it could be converted without extensive rebuilding. Now, moving on from that to where we are now in terms of the additional information, certainly identifies 3 options and says it's feasible that these options may resolve the situation in terms of the structural integrity of the building. your officers are saying that they still require further detail before they could accept that it met the policy in principle. On that basis, therefore, to attach a condition such as you have suggested is arguably incompetent, because you wouldn't normally require technical details that were linked to a recommendation to refuse in principle, because you can't grant planning permission if you haven't been satisfied that it accords with policy in principle. So if you were attaching a condition, you'd be granting planning permission contrary to the recommendation on a technical matter, which could still turn out that these options wouldn't work. So,
Yeah.
you know, the proper way in planning terms would be for the LRB to uphold the recommendation and for the applicants to submit an amended application, having carried out the further investigations that their advisors themselves say are required. So the proper planning procedure would be to uphold the refusal, the applicants to go away and carry out these further investigations, establish which of their options was the preferred one, submit a new application with that option included in it, with all the requisite details in terms of drawings, etc., that your officers are saying are required.
And is there enough information contained within the officer's original response to the application when it was refused and the subsequent letter from Robert Duncan to encourage the applicant to carry out these studies?
I would say so, because the further comments from the appointed officer accept that. I think the relevant sentence is the information provided, however, confirmed that there is a way forward, although not specified at this point. So I think your officers are accepting that there is potentially a way forward, but further detail is required.
Okay, thanks for that, Billy. Okay. Given that it would appear that my proposal is not competent, there is a way forward, which is the applicant has carried out a significant piece of work, being encouraged by the appointed officer that they have gone a part way to addressing the problem, but we would be seeking confirmation that proposed works would have no impact on the external appearance of the building, and that ideally should be carried out a structural survey and propose a detailed solution before any formal support can be given. It doesn't say that in the letter, but that's the inference being given by the council. So on that basis, members, it would appear that we will have little alternative but to refuse this appeal on the basis that the additional information that we require to support it has not been provided to date. I'm looking for just either confirmation that members are happy with that, or if they have some alternative suggestion that will meet with our requirements. I know that as a LRB we have the right to change, amend or support the original case officer's decision. That's in our hands, but I want not to do that if it was in breach of council a policy. Billy, you're muted, Billy.
Apologies, Chair. Yes, I thought it might be helpful just to give a word of advice in terms of any resubmission in terms of application fees. From the applicant's point of view, it would actually benefit them for the application to be refused, because they would benefit from a free application within 12 months of the date of refusal. Whereas if they were to withdraw the application, they would not benefit from that, because if an application is withdrawn, the free application is 12 months from the date of original submission.
Thanks, Billy. I've got three members now. I've got Pauline Drysdale, Henry McClelland and Jeff, and according to my Fiona, it's Pauline, Jeff and Henry in that order. So Pauline, please.
Thanks very much, Chair. I suppose for me it's a bit complicated because with regards to the timbers, that is inferring from the report that it's just the roof that would be affected. But I could be wrong here, Billy. You know, I'm not a structural engineer. But to me, if the masonry walls remain intact, it would now meet policy H3. But again, the roof might have to be included, and wherever else the timbers are going to be part of that building, so it possibly doesn't. I'm just not clued up enough to know whether an extra report would be needed or not. So I'd probably prefer clarification on that, Chair, before we go forward with any decision. Thanks.
Thanks, Pauline. I think part of the report says there are bulges in the wall and they're being forced out because of the roof collapse. So the roof's linked, obviously, to the wall, and there's one of the suggestions to build an internal wall to take the weight away from the original walls. But Billy, can you help Pauline, please?
Yes, I think the timber question is something that has been introduced at a later stage, and they themselves say it's a further consideration. What you're really considering is the structural integrity of the external stone walls, where they are bulging and unstable at the moment, and buttresses have previously been introduced to secure that. I think to some extent the now reference to the timber in the roof and possible infestation, etc., is something of a red herring in the context of your considerations today. In other words, I don't think you need to concentrate on the question of the timber. It's the structural integrity of the building and the walls that you're considering here.
I think as well, just to probably reinforce what Billy's saying, the timbers are internal works and it's the external appearance of the building that's the main concern. Jeff, please.
Thanks, Chair. Yeah, I'm fully supportive of bringing these two buildings back into use, because otherwise I think they will just end up being derelict and eventually falling down. But since they are proposing to carry out further structural surveys anyway, I think in terms of, if you like, the security of the council in this, I think we should uphold the officer's recommendation and allow them to come back with a further application once they've carried out these surveys and come forward with a definite solution to the problem.
Thanks, Jeff. And I'll ask Billy if that's the feeling of all of the members of the group, if he's allowed to, just to refresh our memories on which surveys the council requires, and we can then build that into our reasons for refusal, if that's appropriate. But I'll do that at the end. Henry, please.
Yeah, thank you very much, Chair. I totally would, as per Jeff there a couple of minutes ago, I really would like to see these the development taking place, but I do understand the situation regarding these structural reports. I'm well aware of that with a number of applications that I have been involved in. So what I would like, Chair, again, I would support upholding the case officer's decision, but in terms of supporting the refusal, but in the same token, if we can have a form of words that would show the way forward, because it does appear from the case officer that the case officer is saying there is a way forward based on the three options, but there's further structural reports required. So I would like to see our response in that way, supporting the case officer, but giving a steer to the applicant that the expectation would be for these satisfactory reports to be provided to allow this to move forward. And again, that would be at no particular cost other than the cost to the applicant of the surveys.
Thanks very much, Henry. And you're absolutely right. And I'm sure the applicant or the applicant's agent will be present, or he'll certainly take account of the discussions that have taken place, and that should encourage the applicant, if they so choose, to follow that particular route or path. I have Laura looking to give some advice. Laura, our legal representative, please.
Thank you, Councillor Dempster. If it is the case that the review body feel that with further information they may be able to make a different decision, then it would be competent under Regulation 15 to ask for further written submissions.
Thanks, Laura. I suppose that's helpful, as long as the applicant can, after that time, still have a 12-month period to submit a reviewed application free of charge for applying permission. Or are you suggesting that we require a whole range of studies to be carried out and then we simply make a decision ourselves? It's quite clear, I think, and you'll have recognised that, and so has Billy, that there's a degree of sympathy to the applicant, because we feel that it'd be beneficial not to have these buildings remain derelict, but to be brought back into use. And we're also conscious that we do not want to be destroying council policy or undermining it unnecessarily. And the policy is quite clear. There's indications or guidance from both the case officer and the appointed officer that other work requires to be done. So my question to you is, I'm sorry it's a protracted one, but if we ask for these studies to be carried out, I take the case officer then has sight of these studies, and the case officer then makes a recommendation or presents a further observation on the new information, which might be that they still, for whatever reason, don't support the proposal because of the outcome of the studies. So do we then determine that, and it could go on quite a prolonged period of time? Or just simply to finish it today, and then the applicant has a very clear direction and outcome, and they go back to dealing directly with the case officer, whereas at the moment we will be instructing other work to be done. It will then go to the case officer and then come back to us either through the case officer's observations or the appointed officer.
To take a step back, at the last hearing, it was decided that in accordance with Regulation 13, you wanted to have further written submissions before you could make your decision.
Yeah.
And you got that in the form of the Christie Gillespie letter of the 12th of August. Now, that letter has identified, as you highlighted yourself in the penultimate paragraph where it says it is feasible, it's identified that further reports from a structural engineer would give more information on the proposed works. And if you look back on the emails from the case officer as far back as November last year, that is what she has been requesting, is this structural report to get the further information. If the local review body felt that receiving further information by way of a structural report would then enable them to make a decision, then it would be competent for them to ask for that, to reconvene, and at that point decide whether that further information by way of a structural report enabled them to decide in favour of the applicant. Now, that would not be undermining the policy or the supplementary guidance, because the case officer had indicated that she needed that information by virtue of those policies and supplementary guidance.
Okay, I've got two. It might be that Claire, I noticed Claire Rogerson wants, our governance officer, wants to speak, but before that, I have two other thoughts, and either Claire can touch on them all or you can. Firstly, if we request that, I take it, can we also place a time limit on it?
Yes, the procedure note would state when it had to be submitted by.
Because there are local government elections in May, and I know it's 6 months away, but some members who are on the LRB may not be elected members after that period of time, or after the 5th or 6th of May, whenever it is. So that would mean a whole new hearing unless we got that information to hand before local government elections and probably before Purda. Otherwise, it could be argued we'd be looking to take advantage of a political decision, or a decision that would become political, if that makes sense. So I'd be keen, if we are going to do that, that we do that with a very strict timetable. But I've got Claire wanting to come in to give us a governance guidance, and then I've got Pauline Drysdale wanting to speak, and Fiona Brown did say our last LRB meetings in March. This would be a reconvened one, which would be completely different from scheduled ones. So I've got Claire first with governance advice, and then Pauline Drysdale.
Okay, thank you, Chair. All I was going to add to what Laura was saying was, obviously it's purely a matter for members of the LRB, but which further procedures, if any, they wish to pursue. And yes, there is a local government election in May. Normal business of the council would continue up until that point.
Yeah, thanks, Claire. So I've got Pauline and then Henry. It would appear, though, from Laura's advice that we can put a strict timetable on this, because I wouldn't want it. I think it's no fair on the applicant nor the council members and staff that this goes on indefinitely. Paula, please.
Thanks, Chair. I think probably we need some clarity from Billy. I know Councillor McClellan's probably got more knowledge on this, but to me it seems that, am I correct in thinking it's another 3 reports that need done? A timber survey, a foundation survey, and I saw another list of something else. You know, are these something that we could be advised on? Is it possible to do that amount of extra reports in the amount of time that we're looking at here, Chair? That's really my concern. Thanks.
Thanks, Pauline. And if no, then we simply refuse the application and leave it in the capable hands of the applicant to come back when they feel it's appropriate to do so. I've got Henry, Ian Blake, and then Jeff. Henry, please.
Yeah, thank you, Chair. Yeah, I feel different now in what approach I'd like to take, having listened to Laura's advice. I was going pretty much with what Billy was suggesting there as the only way forward. But no, I believe that, and I'd like to take this forward, Chair, that we should ask for the additional structural reports, whether it's 1, 2 or 3 of them. We ask for these reports in a timely manner, and I would suggest within 3 months, so that there is time then for the local review body to reconvene, and the case officer would be able to feed back their comments as well. Again, I stress the case officer has stated there is a way forward here, and the initial structural report is suggesting that there's 3 options. So again, I think it can be done in a timely manner, and I think we can reconvene before Purda kicks in.
That's fine, Henry. I'll ask advice at the end of the conversation, because Jeff and Ian are still looking to come in. But I would presume, unless I'm told otherwise, that if we ask for these reports to come in 3 months and they don't come in 3 months, that becomes an automatic refusal, and it then moves back to what was suggested as the application refused until, or we could place that as a further condition. But as I say, I'll ask for that advice last. I've got Jeff and then Ian. And you again, Henry, unless your hand's a legacy one.
Thanks, Chair. Yeah, I appreciate what Laura's saying, but I think this is the cleanest way would be to uphold the decision of the officer and refuse the application in this instance, and allow the applicant to carry out the surveys and come forward with a proposed solution to the structural issues and submit a new application. I certainly won't be standing. I won't be part of the local review body beyond May, because I'm not standing for re-election. But I think that puts an artificial time scale on this, and as Pauline says, I don't know how much work is involved in carrying out these surveys. We don't know what's going to happen. So I think the cleanest way would be to refuse it and allow the applicant to carry out the work which they're proposing to do anyway, and then come back with a new application.
It would certainly take us out of the picture, Jeff, if the application was supported then by the case officer. Ian Blake, please.
I'll just come in, Jim. I think this just ended up being battered backwards and forwards for quite a while.
Yeah, I think you're right, Jeff. Ian Blake, please.
Thank you, Chairman. I've listened to it carefully. I think we're almost putting a confusing picture on it. We're here to review the case, and we did ask for further information. We got the information, which is inconclusive, in that it needs even more information. I think the cleanest way forward would be to refuse it, just to go on the recommendation. The door is open. We could put a covering note to it or whatever, encouraging them to do the structural survey. But we've done our job here. I think to confuse it with the local elections is almost putting a false picture, and I don't think that should come into it at all. That's just the timescale of things. I would be in favour of refusing it at this time. I'm very much in support of the application, but in assuming work can be done, but we don't know that yet. So I think we should just refuse it today and encourage them to resubmit when they have the full information. Thank you.
Thanks very much, Ian. Well, it seems that I'll come back to you in just a second to see whether or not that's a formal proposal by you and Jeff. But no, what I thought was it would have fallen anyway if the replies or responses hadn't come back in 3 months. But Laura wanted to come in. Laura.
Thank you, Chair. It was just to confirm, yes, if you did proceed with having more information submitted, and then at the next meeting you determined that you didn't have sufficient information, either because it hadn't been provided or it was inadequate, then yes, it would be within your gift to refuse it at that point. I would counsel, in support of what Councillor Blake said, that any suggestion that this decision is linked with the forthcoming elections should be removed. The timetabling, that should not feature within a planning decision, the idea of the timetabling of the decision making. If the decision is that you feel that for planning reasons this should be refused, that is fine, but it should not be linked in with the election timetable, as it's not a planning matter and it's not a material consideration.
Thanks, Laura. No, I was simply pointing out during the debate that the members of the LRB, as made up today, would not be able to sit on this particular application had it to extend beyond 6 months, because I knew Councillor Lever at this moment wasn't intended to be with us. So the whole LRB would have to be restarted again with new members, and that unless we have a quorum, of course, but that might have extended the timescale. So no, it was never an intention to link it to the local elections. It was simply to suggest that it may be the makeup as such that the LRB could not have met after the 5th of May because they wouldn't be in existence as members of the Dumfries and Galloway Council. But no.
Thank you, Chair. It's just worth clarifying that.
Aye, thank you. No, it would appear in any case that we have a way forward. Councillor Lever has proposed it, which I think that we refuse this, and I think Councillor Blake seconded that proposal, and I'll ask Jeff, is that correct, Jeff?
Yeah, that's correct, Jim.
Councillor Blake, are you seconding Councillor Lever's motion?
Yes, certainly.
I've got Henry with a proposal. I mean, I would go with Jeff Lever and Ian Blake, and it maybe be better with a consensus. But Henry, do you have an alternative view?
Yeah, Jim, I'm not going to take it to a vote because there's obviously a consensus. So I'll withdraw any counter motion. It's wasting time.
Thanks very much, Henry. Pauline?
Yeah, thanks for letting me back in, Chair. I just have one concern. I understand the governance issues with not being able to advise the client, and potentially that there could potentially be a timeline on this. I think as councillors, we need to be aware as to what would happen should the applicant not be able to get all these surveys done in a timely fashion. There are delays in building as such. I don't know about surveys and structural reports, but obviously it's a bit unfair on the applicant if they try and come back and it's after a certain amount of time and this panel cannot be reconvened due to certain members not standing again, or perhaps some of us not being re-elected. So where do we stand legally on that, Chair, with regards to protecting the applicant? Because I think we do want this, you know, we are in support of the actual application apart from the legalities. Thanks, Chair.
Thanks, Pauline. I think we've just circumvented that concern or that discussion. We've decided Councillor Lever has put up a motion to refuse this application or this appeal today, based on the information we have to hand and the fact that we would have required more, been seconded by Councillor Blake, and I'll ask them both to verify exactly the reasons for refusal. And that means the applicant will have as much time as they want to take to bring forward a new application. As Billy Murray has said, just simply in general advice to us, if the applicant within a 12-month period of today, I presume, submits a new planning application, there will be no cost for that submission. So the only cost would be for the studies which they would have had to produce anyway for this LRB. So effectively, the decision today will bring this LRB to an end, and we will no longer have to sit on this appeal unless the same cycle happens again sometime in the future once the studies that have been requested have been submitted to the case officer. So your concerns have been negated now because Councillor Lever has put a motion up to refuse today. Councillor Blake has seconded it. Councillor McLaren has indicated he's not intent on putting an alternative view forward. Therefore, it will be a consensus that the LRB today have refused the application on the grounds set out by the case officer. Jeff, we just want to confirm your reasons for refusal today, please. And Ian, I'll ask you if you'll verify them.
Yeah, I think it's due to the lack of full structural surveys and an agreed solution to the problems associated with the structure on the basis of those surveys.
Thanks, Jeff. Ian Blake, are you content with that as a motion?
Yes, I'm content with that.
Thank you. And Billy Murray, Billy?
Yes, Chair, it's just to say that my reading of it was that the LRB wouldn't have to come up with a reason for refusal. You're upholding the reason for refusal that is already in place. So you're upholding that reason for refusal, and that reason for refusal in itself indicates that it has not been satisfactorily demonstrated. But it's clear that what in the papers, it's clear what further surveys, etc., are required. I may be stepping slightly outside my remit here, but would it be possible to uphold the reason for refusal as it stands and in the minutes give an indication of what approach the LRB expected in terms of a positive way forward? The only other thing to say would be that in terms of a new planning application, I think it's pretty clear in reading the papers that all parties are more or less agreed that there is a way forward, and that form of words is used by the appointed officer. So hopefully, if they were to submit a new application, these matters could be resolved and it would result in a delegated decision.
Thanks very much, Billy. And I see Jeff has hand up. He's maybe wanting to modify his motion, and I know you don't present motions. So thanks for the advice, Billy. That'll be down to Councillor Lever. Claire Rogerson first, please, and then Jeff.
Thank you, Chair. I was just going to advise that the decision notice that follows this LRB would provide the detail of how the LRB had come to the decision it makes today. And there's always the option in the minute to provide a further request from the LRB to the applicant or agent if the LRB is minded to uphold the decision.
Yeah, and I take it will not be so much request as advice, Claire, because we'll simply be saying that we would like to see this development proceed, but following the proper or due process. Jeff, did you want to come back in?
Yeah, just to say I'm happy with what Billy and Claire are suggesting, and we separately advise the applicant of the reasoning behind the decision to uphold the case officer's verdict. Thanks, Chair.
Brilliant. Thanks very much. Ian Blake, are you content with that revised motion?
Yes, certainly.
Thank you. I've got two legacy hands. Are you wanting back up, Claire or Billy?
Mine's a legacy, Chair. Apologies.
Thanks, Billy. Okay. In that case, members, we have arrived at a decision, and the decision being to refuse based on the case officer's decision at when they considered or she considered the application. Claire, just for the very last thing before we leave, can you confirm the committee decision and the basis for it, please?
Thank you, Chair. I can confirm that the local review body have agreed to uphold the decision of the appointed officer for the same reasons as stated in the report. Further, the local review body have asked that the advice is given to the agent and the applicant agent on the way forward with the application.
Very great. That's very kind, Claire. Thank you very much indeed. Members, that and officers, that includes my meeting today. Thank you very much for being present. Thank you for your time. I look forward to seeing you again. Thank you.